as you would have gathered the last time, we're essentially repeating the class of last week. Remember the fire alarm crept up on us, and so we will be having seminar 7. Is it seminar 7 or I can't remember now, but you know what I mean, at the appropriate time, i.e. when we are advised by the school authorities. Remember, there's going to be a replacement class, right? So what we're doing is having this seminar that was aborted somewhat last week. We had about an hour from that one. We didn't complete. It was meant to be a 2-hour class. So we will not be losing that. We're essentially having that again, right? Do you understand? You're looking like you don't understand. That's wrong. Oh, okay, sorry. That's what I was over-explaining. And as soon as Chris gives us a schedule, then we will have the seminar on tunneling, the last one I uploaded. You would have gathered that that's so the seminar from last week, if you remember, was quite a long one. And we actually sort of got midway. I remember the point where we stopped, where I was talking about Justice Frankfurter's quotation in the case of U.S. SEC and Chenery. Remember where he says to call a man a fiduciary is merely the beginning of analysis. So that really was to be the framework within which we would carry on the discussion, right? And that's where I'm going to start today. Right, so if you turn to that seminar sheet and go back to where he says to call a man a fiduciary is merely the beginning of analysis, we are going to use the questions he posed, right? So I'm referring to the seminar for last week. Okay. So the questions he posed: to whom is he a fiduciary? So if you notice the number of cases there, we're going to be talking about cases like Peskin and Anderson, right? Percival and Wright, right? So so we're going to use that framework, and we have ample time. So we're in credit, right? So we have ample time to discuss that. And then, as a prelude to the next class, the one whose seminar materials you already have, I thought I would say something about that particular seminar because what I did was to give you the OEC document. I think I uploaded an OEC document, and the OEC document discusses related party transactions and uses a number of jurisdictions. So you'll see that there's Belgium, Israel, and the idea basically would be to conduct the analysis within that context. I'd like to get us to share insights from your various legal systems. So essentially, I would require you to dig in a bit and tell us how we deal, or how you deal with related party transactions, right? Because there are different ways of dealing with it, and some systems deal with it poorly, others deal with it really well. And that essentially is the thesis of Laporta's article. If you remember, I gave you a reference to Laporta's article where he talks about tunneling. Right? So the term tunneling is essentially a type of, or a consequence of a related party transaction. Right? The idea of tunneling came from the Czech Republic after the collapse of the Berlin Wall. There were a series of privatizations and moving from state-owned enterprises to private hands, and some writers described a process by which those who had conduct of this process were able to transfer state owned assets into private hands. I suppose this could apply to Russia and the emergence of the oligarchs, right? So that short period, you saw a rapid transfer of state-owned assets into private hands. So the idea basically is that you're tunneling, almost like tunneling into a bank. I'm sure you remember all those old films where robbers tunnel into a bank to basically take assets away from the company. Or in this case, from the bank, I suppose. And I suppose it's not as simple as saying, well, the best way to prevent tunneling is to prevent related party transactions. After all, directors are fiduciaries. If a director is a fiduciary, which we're talking about today, if a director is a fiduciary, then a director should not really be allowed to deal with the company. It's not as simple as that. Legal systems have to permit a degree of related party transactions. So the question then is, how do you draw the line? Do we say, so I suppose the different staging posts, you could have complete prohibition. On the one hand, you could say, well, the board should approve with disclosure by the directors. Or you could say, let's get the shareholders involved, right? So instead of just saying, well, the directors approve the related party transactions. So I want to buy a property from my company. My company has a house in Chelsea, and I want to buy it, right? You could prohibit me from dealing with a company, right? So of all mankind, I should be the one never to enter into this kind of transaction. Right? That's the way the common law would deal with it. Or you could say, well, let's get the directors, right, and exclude you from the decision-making process so that the directors decide. Well, as I'm sure you can tell, this would lead to you scratch my back, I scratch your back. Right? And the third option would be to say, let's bring in the shareholders, right, to deal with this. So these are just sort of broad outlines, and I'd like us to think a lot about this as we prepare for that class. So I take you back now to the framework for analysis, which you will find on page 7. I did skip, perhaps I shouldn't. Actually, no, I should go back a bit, because now I remember, although I used that framework for analysis, there were a few rudimentary things which I think I should pick up. They're a bit boring, but we need to know them, and I'm sure Nigel will deal with them. So we're talking about the different types of directors, the jury executive. It's kind of standard company law stuff, but I probably will just say one or two things. I've been talking in the hope of getting this thing to work, and for some reason it looks like it's completely stuck. So maybe I should just try to reboot it. This is why I was just going on and on and on. Let's, oh dear. I better call them. That's the point. Hi, good morning. I am in K minus 1.56. Yes. And the controller is trapped in a loop. So I can't bring it up. You know, the controller for the AV equipment. All right.
Will have somebody help you?
I'll be grateful. Thank you. Okay. Okay, so we'll just dispense with that for the minute. Okay, so as you know, the framework we use is a framework we borrow from law and economics, and that framework talks about agency cost, right? It's a law and economics concept. Although some years ago, I think Justice Hoffman, Lord Hoffman, used it, appropriated it, and not even in a judicial context. I've not really seen it sip into the case law. But the idea essentially is simple. The idea is that if you use agents, if you use directors to manage the company or to supervise management on your behalf, then there's a risk because of the conferral of authority on the directors, this large scope of authority. There's a risk that the directors may not be loyal. They may not be loyal. They may not serve you well. They may not be faithful. They may be negligent. That is a cost, and that is regarded as the cost of having somebody manage your property for you. And we call this, yeah, thanks. It's
yeah, so there's a problem with the network in this room which causes this. So this is actually on here now.
Oh, I see.
So you can actually use it from the desktop now in the same way.
Oh, I see. Okay, so we'll just go.
Yeah, it's on there.
And then.
Oh, yeah, so you're using it. Yeah.
Okay.
So it's just on there.
Thank you. Okay, so I was referring to, I think it was Michael Jensen who came up with the idea, Jensen and Mecklin in a paper in the 70s, who came up with the idea of agency cost, and they defined it as the cost inflicted on the company by its agents. Now, when economists use the term agents or agency, they use it in a very loose term, in a very loose way, not the way lawyers use it, right? So it's essentially used in a functional way. And lawyers, in a sense, have appropriated that term. So when we look at corporate governance and we say, okay, we know the business of corporate governance is about having an effective board, but assuming this board is not very effective, right? How do we quantify, how do we measure the consequence of malfeasance, the consequence of misfeasance, the consequence of sloth? How do we measure it, right? Now, and also, how do we measure the cost of bonding directors, right, to the company? In other words, how do we align interests? How do we, what things do we create to align the interest of the owners and that of the managers? So, for instance, share options would be one alignment tool, right? But there's a cost to it. Right? You give somebody a share option so that he works well for you, but there's a cost. So the sum total of your alignment costs, right? The cost of sloth, malfeasance, misfeasance is referred to as agency cost, right? Okay. Now, so economists know this and they use it that way. Now, from the perspective of corporate governance, we would say, well, hopefully we'll never have this problem if we have an effective board, right? So that we don't need to deal with it ex ante. Well, to a certain extent, you will have a residual cost, and that residual cost would be the bonding costs, right? Because you've got to have share options and things like that. That's corporate governance. But the lawyer, wearing his lawyer hat, comes in to say, well, I know what to do about this cost. We will sue. We will litigate, right? And litigation is a part of corporate governance, right? So the question then is, how do we litigate? How do we tell the agents to sue themselves, right? The agents are not likely to sue themselves, right? So we need to find another mechanism to step in, right? So we either use the board, right? So we find some independent group in the board. So we set up a committee, maybe we'll call it a litigation committee, of disinterested directors who basically will be able to sue. Or we override the board and permit a derivative action, right? So a shareholder essentially overrides the board to bring this action. Again, legal systems essentially do this. I think virtually every legal system on the planet would have this kind of mechanism in place. How well you're able to activate the derivative action may be a separate question. And and really what you want is to sort of be in the Goldilocks range, the Goldilocks range, not too tight, not too loose. If it's too tight, i.e., if it's almost impossible to bring a derivative action, then agency costs will increase, right? Because nobody's going to sue. Because if you make it too tight and say we will never permit shareholders to bring a derivative action, if you make it too loose, then you're undermining the board and probably killing the company with kindness. Sometimes there are times when you've just got to lick your wounds and just get on with life and not throw good money after bad, right? So that's why I say we want to the challenge for every legal system is to articulate a test that effectively occupies this Goldilocks range, right? Not too hot, not too cold. So that would be one way of, I suppose, dealing with agency costs. Now, and then when we then identify this, we then say, okay, obviously, if things go too bad, then we don't even need to work out who should sue, right? We don't need to work out any kind of Goldilocks range, right? In other words, we don't need a derivative action. If it goes really bad, then the company goes into insolvency. If it goes into insolvency, a liquidator is appointed, and if a liquidator is appointed, the liquidator sues. So we never talk about a derivative action when a liquidator sues, right? I say this because sometimes in exams, people say, even when a company is clear, the company has gone into liquidation, you see students saying, well, there should be a derivative action. I'm thinking, no, the liquidator has stepped in, right, and assumes the powers of the company, and that includes the power to litigate. So the liquidator has no problem bringing suit. The liquidator will simply go straight to the cause of action relevant to the claim. On the other hand, if things have not gone too bad, i.e. the company is not in liquidation, then we decide who sues, in which case we have the Goldilocks problem, either the board, right, or the shareholders. Do you understand this bit? Okay. So, if you don't understand, please let me know before I move on. I'm just sort of trying to, I'm sort of developing the theme here. Remember, the theme is economists come up with the idea of agency cost to capture the sum total of the cost of having divided ownership, right? So that's agency cost. Then lawyers then take this agency cost and say, what do we do with it? What do we do with it? We would like to sue. It then depends on whether the company is insolvent or not insolvent, right? If it's insolvent, then a liquidator steps in to sue. The liquidator will be suing under Section 212 of the Insolvency Act, which is a provision for misfeasance. Misfeasance is simply a summary procedure by which the liquidator is allowed to sue for every bad deed that has occurred. Every breach of trust, every breach of duty can be taken to court through misfeasance proceedings under Section 212 of the Insolvency Act. And you see this in your seminar sheet. Because if we look at, let's take, okay, sorry, that would appear, that would be in the next one where we talk about remedial issues. So let me just quickly I just want to flag this. Yeah. Right. So avenues for the judicial enforcement of duties. Right. So remember now, I always try to make this connection. Corporate governance, we hope, if it's really good, we don't get to this stage, right? Because we have an effective board doing its job and all that, so we don't get to this stage. However, if your corporate governance is weak, right, and duties have been breached, Then we get to this stage, right? And then when we get to this stage, and we've got to sue, because we know what agency cost is, we've put a number to it, right? It's not just some theoretical thing. We have a number. Then the question then is, well, who sues? Who sues? That's the first question. Who sues? Well, we ask, is the company in liquidation or not? If the company is in liquidation, then it's the liquidator, in which case the liquidator will bring an action for fraudulent trading or wrongful trading, assuming there is wrongful trading or fraudulent trading. Fraudulent trading really connotes fraud, right? So most times you're not going to get this for simple corporate governance issues, where you literally defraud people, right? So it's not very often. Just a minute. Wrongful trading is when you're taking big risks. I call it reckless trading, right? You kind of, it's very easy to take risk with other people's money, not your money. So you think that somehow the clouds of adversity will blow away and the sunshine of prosperity will come shining through, and it's always easy to do this with other people's money. So you take on more credit, you trade more, right? But you're digging a deeper hole. Then that's wrongful trading. And if a liquidator comes in, the liquidator will sue those people who caused the company to trade wrongfully, right? And then misfeasance proceedings. See that? Misfeasance, the second one, under Section 212 of the Insolvency Act. It's simply a procedure. I call this the agency cost procedure, right? Misfeasance proceedings allows you to take every type of agency cost into the courthouse and say to the court that there's been, negligence, related party transactions that are unlawful, every bad deed, and I want a remedy, right? There's been misfeasance, right? It covers not just misfeasance, it covers malfeasance, real bad faith, it covers everything, right? So that's under Section 212. Now, the third one, action by the company through its constitutional organ. So if the company, right, what's the constitutional organ of the company? The board, right? The board basically has the business of managing the company, isn't it? Of managing the company's affairs. Now, so in order to solve this Goldilocks problem, right, of, how do we strike a balance between undermining the corporate rights, right, to bring litigation, or rather to decide whether litigation should be brought, right, or giving shareholders a wide latitude in suing on behalf of the company. Now, these are the two polar opposites, isn't it? If I permit all of you to sue, and you're members of the company, effectively what we're doing is we are undermining the company. We're undermining separate legal personality, because it's not your cause of action, it's the company's cause of action. We're basically overriding the company and allowing you sue, right? And it could be said that this is not really good, right? Because we're undermining separate legal personality. On the other hand, if we say, well, we will never let you sue, no matter how bad the behavior is, it should always be the board representing the company. Then again, that's too bad, because in some cases the board will, they will harm the company and will never sue. So the challenge is to get that middle, right? The challenge is to get that middle. One way you could get that middle is by using C to say, okay, you know what? Let's look at the board. If we have a board of 15 people, and 5 people clearly had no connection whatsoever with this, then we should be able to trust them to take that decision, right? So you set up a litigation committee. That's what the Code of Corporate Governance talks about when it talks about board committees, when it talks about the structures to be put in place for good corporate governance. You set up a committee. And, and the thing about these committees is that sometimes people say, oh, well, they never work. They do work. I mean, it depends on the committee. There's this body called the International Senior Lawyers Project, which I think I mentioned, we do pro bono work. It's a big NGO. And so I'm on the board as a director and trustee. And so there was a sort of grievance proceeding, and we needed to set up a committee to look into it. And so in this case, it was just a committee of one person to do a grievance report. And so, I was chosen. And, and my report basically was a bit surprising to maybe the person who wanted me to do the report, right? In other words, it's possible to be independent, right? Because the person who kind of nominated me, even though we never talked about it, I simply tried to steer an objective course in the pursuit of truth and justice, and to try to resolve the matter. So the point I'm making is that in committees, it's possible to have wise decisions. If you have a committee, I would prefer to have a committee on litigation that is completely disinterested than every time to go back to the shareholders. Because, you know, the shareholders will take stupid decisions, right? They will throw good money after bad. You know, shareholders are not able to understand litigation risk. It's not every time you have a so-called good case that you succeed. You know, people have been known to snatch a victory from the jaws of defeat. You know, so you know, I think it does make sense to explore processes within the board. If you do that, and the board then says, we will litigate, we will sue that director, then it goes under 3, right? Because here it is an action by the company that has delegated that decision making to an organ, to a committee of the organ to make this decision. Obviously, we go to E. If the shareholders, the board chooses not to sue, and they are acting in a conflicted way, they're all sort of interested, so we can't trust them. So in that case, the shareholder goes to court and says, please, 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 permit me to sue on behalf of the company, and I'm not going to take the money and run away with it because my claim derives from the company, and therefore any damages you give me, I will hold and return to the company. So it's derivative, right? So you go under E. Of course, if you think that it may be risky going under E, right? Because the court, you know, because for you to go under E, you've got to persuade the judge to allow you override the board, right? To override separate legal personality. So there's a big risk there. So if you think you may not be successful, then what do? You go to court and say, you know what these guys have done has cost me prejudice. It's unfair, and I want a remedy. So you're not suing in the name of the company, you're suing in your own right. And English law is really good in dealing, I think this is one of the advantages of English law in having this procedure, this flexible procedure for unfair prejudice, right? Because what it does is, by some strange alchemy, it takes a corporate right, right? A corporate right, and makes it into a personal right, in effect. So the company has been damaged, but the shareholder is able to go to court to say, I have been damaged, right? I deserve to sue, and I want a remedy, right? And the courts are able to do this. We're going to deal with this later on. But the point I'm trying to make here is just show the connection between agency cost and remedial issues. Obviously, if the liquidator brings an action under A, all right, he could then say, you know, I want the directors to be disqualified, right, because they're really bad people. They should never manage a company again. Somebody was about to ask a question before. Yeah.
So you talked about effectiveness, but how can we define effective a board which allow the chairman to be the CEO at the same time?
Well, we think that an effective board is one which separates, right, those roles. However, if you want to collapse those roles together, then you have to disclose to the market and explain why. Now, if you explain and you do not suffer a penalty in your share price, then it must be that that is effective. Right? It must be. So there, you know, I mean, before Elon Musk started smoking hash on live radio and, you know, accusing people of being pedophiles with no proof, right? Clearly, he was suffering from sleep deprivation and so many other things. I think most people would say this is the guy to be chair and CEO, right? He was so successful. But when it became a problem, the US SEC intervened. And interestingly, even though in America you don't have that rule, what they've done is take the UK rule and make it into an instruction. So they say, they hit him first of all with a fine. He's very rich, so it won't. But they also say, let's split those roles. So I think that, I think that would be the answer.
Anyway, the risk of capture still remains. The
The risk of who being captured?
The directors.
But the problem with the reason why we have a separation is the concentration of power as opposed to capture, isn't it? In other words, we talk about capture when power is diffuse, right? And because power, if everybody has power here, if you have power, then my goal will be to capture you. If I'm bad, right? My goal will be to capture. I don't capture you if you have no power. But if power is concentrated in me, because I'm the chairman, I'm the CEO, I decide what you read, then power is not diffuse in the first place. So ab initio, there's no need for capture because I have all the power, right? So that really used to be the problem with UK corporate governance and generally, and that's why we then had this rule to separate. But it's not a rule that is mandatory because we have a comply or explain thing. And my view is that if the market is happy with it, then fine. Now, you may say this is a very sort of naive, or not naive, probably. People like Iris Chu would argue against that, right? Because her point would be that many of those companies that, especially the companies with natural resources, so you take countries from, say, parts of Asia that have loaded, lots of natural resources. They come to the London market, and then they concentrate power in the chairman, right, because they don't split. She would say that the fact that the share price does not suffer does not mean it's good. It just means that people are looking at the bottom line, but we don't like this. I don't know what you think. What do you think about that?
There is a asymmetry of information. They don't know what it means. So
Yeah.
That's why the price is not much influenced.
No, the price. If you have gold reserves, right, or you're sitting on, lots and lots of oil, then you really have to do incredibly bad for the share price to go down, right? So we will not punish you just because you decided to concentrate power, right? And so the question then is such a board not an effective board? You may say, it depends on how you define effectiveness. Effectiveness for what? If it's to deliver a particular share price, then I think it's effective, right? We may not like it, but it's effective. But if you think that, okay, this company may not be effective as a good corporate citizen, then that would be a separate question. So in a sense, we need to relate it to values. But if you simply think in terms of share return, I think I'd rather have that. Certainly, I know where my pension money should go. I'll put my pension money there, right? Than somewhere else. I don't know what you think.
Yeah, because like equity funding in America collapsed, and the directors didn't even know what was going on. This is, how can you define an effective board?
Yeah, but that's wider, isn't it? That's wider.
It was fraud.
Yeah. So that's wider. It deals with some of the issues we talked about earlier. That So in a sense, I think the U.S. problem was that of the conflict, I suppose, between independence and industry know-how. They put too much weight on independence, and so you had people on boards who did not really understand the business. Do you see? So, and so now, if you see the code is now trying to de-emphasize independence, right? It's not, if you take independence as an end in itself and you detach it from real life issues, then the company will not really be that great. And so again, this will become relevant to related party transactions. That we can't always live in an unreal region of detached altruism and expect saints to run our companies. The world doesn't work that way, right? Any other questions? Yeah.
About some of the directors who are disinterested in the matter can be delegated by the members, by
The board.
shareholders, or by the board.
By the board, yeah.
So you mean do they can they represent the company in the lawsuit?
Oh, okay. So if there is, say, an agency cost, right? So let's put a figure to it. There is some negligence somewhere, right, on the board, and we think the finance director has been negligent, and it's cost the company, say, £1 million. Then the board then needs to decide whether to sue him, right? And especially if he has a house in Chelsea that we want to take, right? So we need to decide whether to sue him. Now, so in that case, I'm saying it would be good to have a committee of the board, assuming the company's constitution allows for it, that would meet to decide this. So the committee of the board is technically the board, right? It's on the full board, it's a committee of the board. So they then meet to decide whether the company should sue. Now, once that decision is taken, then it becomes a decision of the board, right? And therefore a decision of the company. And then what will happen? The chairman of the company or the company secretary would write a letter to their solicitors, right, to say we have a resolution of the board saying that legal proceedings should be brought against Mr. XYZ. We now appoint Clifford Chance or whatever to bring proceedings. Does that answer your question? I mean, that's exactly how it will flow.
So you mean some of the directors can make decisions on behalf of the whole board, and so that can be the decision of the board itself.
So it is. That's why I said a committee of the board is technically the board. If you just check the articles of any company. If you look at model articles, it says a committee of the board is the board, right? So if the shareholders themselves have agreed that a committee can exercise powers, right? Then they've decided that that should function as the board. Do you follow? Right? Yeah. And by the way, you raised a very important point because this becomes people have tried to use this to validate related party transactions. So in trying to deal with related party transactions, right? Remember I said, the choice we have is, do we prohibit it or do we kind of allow it? Now, righteous folks like some of you would say, let's prohibit it, right? But you're going to be a poor person if you prohibit every related party transaction, right? Because what if that director is, he writes great code for the company, right? And he's been doing this, right? And, you need him, right? So you're not going to prohibit it. But you may say that a committee of the board should look into the contract and sign off on it. And what then happens in practice is that you may get a committee of the board that have not acted honestly, right? and then you see the judges trying to cut the committee down. So there's a case called Guinness and Saunders. Guinness and Saunders decided in the 80s, where I think it was Lord Templeman who said that if you have a provision like that, you should there should be strict compliance with the articles, right? As a way of just trying to control things, right? So I see where you're going, because there are tensions there. But remember, the objective is to achieve a particular outcome whilst obviously trying to control for risk. Okay. Now, so the other point, I'm sure Nigel will say a lot about this. I'm not going to sort of duplicate what he will talk about, but essentially, these are the types of directors known in English law. So your proper director has been appointed, is the de jure director. Now, if he's not been appointed as such, but he acts as director, even though he's not been appointed, then we say he's a de facto director. Now, if I'm acting as a director, as a de facto director, I'll still be subject to the relevant duties, right? So, I'm not going to escape the relevant duties simply because I am a de facto director. And then a shadow director is a statutory invention, right? So that came by statute. And we see this in the context of, let's say, Section 214 of the Insolvency Act. So if a bank, so try and imagine a bank is financing a company and then giving instructions to the directors as to what to do, right? And pretty hands-on, then the bank could be regarded as a shadow director. And if the bank is a shadow director, then that exposes the bank to liability, right? Because obviously the bank has deep pockets. Of course, executive directors are people who work for the company. The trend in corporate governance is to reduce the number of executive directors on the board, right? So most times when you look at the board, you tend to see non-executive directors. As far as English law is concerned, what we expect from the executive director and the non-executive director is the same. As far as English law is concerned, we expect the non-executive director to be as careful, as diligent as the executive director. Now, of course, the fact that the executive director has a contract of service will amplify his duties, and to whom more is given, more is expected. So if you come to the board with a degree in finance from Wharton Business School, and you're in charge of treasury operations, we will judge you higher, right? Because of that subjective element. Okay. But as I said, Nigel will discuss these. I just want to flag up this paper, and the reason I'll flag this up is because you had asked me about this just before this class, and that's why I thought to provide this. So I think your question, so you accosted me outside, and you were wondering whether the panacea of the independent director is good medicine everywhere, right? The malady may be the same, but is the medicine, does the medicine need tweaking? I think those were not your words, but that's essentially what you were conveying. And the reason I think you posed this question was that in societies where ownership is not scattered, not spread out, like we have here, so societies where you rely a lot on sort of family funding or bank finance and all that, the real problem of corporate governance is not agency cost. In the conventional sense, it's minority oppression, right? You see, agency costs, and here this is just a caricature now. Agency costs, the exemplar of it would be a board of directors, or let's say the CEO, who has no shares in the company and who therefore has an incentive to steal from the company, isn't it? To steal from the company. And when we say this, you may think I'm exaggerating that. You know, people do fleece a lot from the company, and that would be the prime example of an agency cost. On the other hand, if that director was a member of a family that owned the business, he's not going to steal from himself. What he will do is take advantage of minority shareholders, right, who invest. So in a lot of parts of the world, the real problem of corporate governance is that of minority oppression. And indeed, when we do this, when we do the reading for related party transactions, and you see the case studies, the OECD one, when you read those case studies, think about the drivers of the problems. You know, the related party transactions in those societies where control resides in ownership, they tend to be driven by a desire to appropriate things which should be shared with minority shareholders. So a big contract comes to the company, you deflect it away from the company to your private company. Now, minority shareholders in your company are not going to be too happy when that contract goes away to your own private company. That's the real problem. Do you get the point I'm making? So that's the real problem. And so your point is that how can the independent director solve this problem? The independent director is medicine here, right? Because the idea is that if the major agency problem is theft by the executives, I'm just being flippant here, is theft by the executives, then let's bring somebody to the board who is independent, right? Who is independent and can identify what's going on. That, right? So that would be the solution. But where it's a family company, what will the independent director do? By the way, independent of what? You know, there was a company which was to be quoted on the market, and so a former student of mine was the legal advisor. You see, one of the perks of this job is that every year you get a supply of potential clients. So the guy gets in touch with me, and they're trying to configure the board, right? And I say, okay, well, you know, we'll need independent directors here and there. And the guy says, yes, you know, we define it. There's a way, you know, and seeing my former company, corporate governance student, telling me, very clear, and there was a way he said it, right? It was in my living room. He had a smile on his face. Yeah, we'll define it. I knew that my labors were partly in vain because, you know, it was clear that he was going to sort of provide independent directors on terms. But again, this makes sense. This is the point you're making, which is that it's difficult to bring in independent directors to solve the problem of minority oppression, or rather, the problem of oppression of the minority by the majority. Now, when you read this, and what I've done is provide the extract where they talk about using independent directors as surrogates, right? And monitors. What was your view about it? Did you read it, this extract?
So I didn't search for the whole article yet, but I read it.
Yeah, did you read it? I mean, this is a key extract, actually. So what did you think? So here, let me just, the authors, so here they argue that boards lack the mandate, incentives, and ability to control insiders, especially in jurisdictions where the main agency problem arises between controlling and minority shareholders, which is what I've been talking about. So they then say that this renders independent directors inefficient when it comes to monitoring, right? That this is not the right medicine, which is the point you raised. So they now argue that let's bring in independents as gatekeepers and independents as surrogates. That's essentially, so surrogates for the protection of minority. And what did you think?
I have to think about it there, but well, so I think this can be, of course, a good solution. But I think what the corporate company X seeks is, on the other hand, like making decisions more efficiently, and so. But I have to think about this.
Yeah, so making decisions more efficiently goes back to the seminar before this, because remember, the seminar before this, there was another paper we talked about that dealt with process issues. Did you read that paper? Again, sometimes I wonder whether summarizing the paper is actually counterproductive. So you end up not even reading the summary, all right? Because the summary is to kind of whet your appetite and perhaps to reinforce, because essentially what I summarize would be the key aspects. I don't take the abstract, I take the kernel of the argument. But basically, what they do in that paper is look at the workings of the board. How, even if you have independent people, how do we bring them up to speed? A lot depends on the information they have. A lot depends on how much time they have, how much information they have. And who gives them the information? The executives. Right? So the executives basically decide what they get. And you would have to be really highly intelligent to ask questions, questions that would elicit more things if a dedicated executive do not want you to ask those questions. Because they will bombard you with irrelevancies, right? And do it in such a way that you would only ask the questions they want you to ask. And that's what the author deals with, that particular problem. And also the fact that they talk about programmatic and non-programmatic decision making, and that some things are easy when it comes to routine matters, but out-of-the-box thinking may be a bit difficult. So you might want to read that paper, right, which deals with the processes. But this paper, I thought you would be really interested in this. And for those of you, and I actually think most people come from jurisdictions that have this type of problem. Is my sense correct? I mean, because if you look at most civilian jurisdictions in Europe and South America, Asia, they tend to come from, those jurisdictions tend to be a bit different from, say, the UK and the US, which relies more on equity finance. So what do you think about the solution? So let's kind of work through the solution here. It says, just in case you've not read it, so it says independence as gatekeepers for the regulator and independence as surrogates for the minority, right? And it says here that independent directors have been seen as the magical solutions to corporate governance problems, but and the authors say this is really strange, right? Because the problems are different. She then says that the drawback to the optimistic view of the board is that the role and rationale of independent directors remains largely under-theorized, and empirical research does not support the high expectations, right? And even though minority expropriation is the most important agency problem in most European countries and developing economies in Asia and Latin America, the focus of research on boards has been on their role in the agency problem between managers and outside directors. And that's typical of the UK and the US, right? And I always like to sort of give, to sort of concretize this so that you know it's not just all theoretical, right? It's real. When you see directors, the case that was decided in London here, where a director literally stole close to $1 billion, right, from his bank. Kind of, I mean, when I mentioned the sums, people thought, wow, this can't be real. But it's reported, you know, and I acted as expert in that case, and the sums were just mind-boggling. But now, I mean, you read about the wealth order, the first wealth order that was issued against the wife of the banker from some country abroad. I think she spent like how many millions? 16 in Harrods. Now that's the kind of customer you want, right? And you know, it's just the mind boggles. You know, 16 million, right? But she's the wife of the partner of, you know.
It wasn't earning a lot. It was earning like, I don't know, but it was like 50,000 a year.
Yeah.
And she was spending over $1 million a year just to Harrods.
You're too kind, to point that out. You know, people always kind of forget that. Oh, she spent 16 million. And, yeah, but I agree with you. But even $1 million every year in one shop, because there are other places that you can buy beautiful things outside Harrods. But you know, and just in case you think that you know, this problem is a male problem. Again, here I have a list of about 20 pages, right? You see, so this is a forfeiture list. There's a lady who was heading a bank and literally looted her bank blind, right? And the properties were just like one after the other, like that, from the States, like that. It just goes on, right? Like that. So, and that's page 20. It was interesting. So now that the properties were taken, the interesting thing was that the regulators moved in, right, to take the property, because obviously this is wrongful conduct, but this also was unfair to the shareholders, right, because that then goes to the state, and the shareholders don't get anything. Did you get the point? So in the competition to enforce anti-corruption laws, the state is also grabbing a lot, right? The state, in this case, the state moves against the lady, seizes all this, and these go to the treasury. And then the shareholders are left with a bank that has been looted completely. And so if you bring a derivative action, or in fact, presumably you don't need a derivative action, you'll be able to convince the board, the new board, to sue the lady. I mean, what are you going to get? Do you get the point I'm making? If she's been denuded of all these assets, I mean, what would you do? How would you solve this particular problem? Imagine this was a problem question, right? And you were to advise the board. What will you do? Yeah.
Why is the state entitled to keep the assets if it can be traced back to the company?
Well, the state, you see, when you deal with, and there's money laundering, proceeds of crime, then the state steps in, right? The state is really bullish. I mean, depending on the laws, some laws, like in the UK, even in the UK, it's been a bit not very well recognized. And so in the UK, the Proceeds of Crime Act somewhere has a provision which says, well, if the victim steps up, right? The victim, yeah. And I've seen this in the context of a national state a federal state where the governor of a subunit steals so much from that unit, and the money is here, and then the UK authorities then take the money, and the government actually makes a speech. The Chancellor, Osborne, then made a speech that recoveries such as this are important for dealing with our structural deficit. You know, as the government is saying, we have a structural deficit, but these recoveries are good, right? And that's because nobody's thinking about the victim, right? Because I said they're kind of buried somewhere, right? And then it becomes slightly problematic, because if the federal government or the state is not the victim, because the federal government is not the state government, they're two different entities, and the state government is not likely to say, I'm a victim, if the state government is still controlled by the thief. Right? So where does the money go? The UK. So, and that's, you know, we see this every time, even with police, you know, policing, seizing things and all that, they want to keep it to themselves. So basically, all that disappeared, right? And by the way, just one slide, you know, the woman escaped jail time, right? You know, and she escaped jail time by saying, I will do a plea bargain. Sorry, but I kind of wonder, why do it? What's the plea bargain? Your hands are found in the cookie jar. You know, who are you shopping? You're not shopping anybody. You're already there. And so there was no jail. She just lost this, and the shareholders basically lose everything. And the bank disappears, right? And now this other one, again, was, this is the one I acted as expert in. So if you sort of Google it, we're talking about proceedings which led to the theft of assets from a bank close to $1 billion. And I would go over the facts when dealing with related party transactions, because the way they use the parent subsidiary structure to do it, and then even the way they went around getting the consent of the board, right? Really interesting way, right? And it's a good way to test your understanding. So when we go over the law, I would like to put forward this fact pattern and then ask you to see how to apply the law in this context, because that, you know, that would be key, right? So, so I go back to where we are. So essentially, the writer here is saying that the best way to use these independent directors is to change things somewhat. So I hope you can see this. They said, to this end, we present two different proposals for reform: independent as gatekeepers for the regulator. All right, so gatekeepers for the regulator, that means you can blow the whistle, right? And independence as surrogates for the minority. Both proposals are very radical, but we believe that radical choices are necessary if we want to save independence from irrelevance. So it talks about, you know, the literature not showing a direct link between independent directors and firm performance. And yeah, so it'll be interesting to see whether, I mean, when you read the paper, think about what does the author really mean by independence as surrogates. I was hoping that you'd have read it, and you know, we'll talk about this, but hopefully some other time. Think about this, that, you know, the gatekeepers issue is pretty easy, right? But what about surrogates? You know, in a family company, how can the independent director become a surrogate? Yes, and so here was the analysis we started with. So this is pretty straightforward. To whom is a director a fiduciary? This is core company law, but it's important to know, because if you don't know this, and anytime the company suffers a wrong, and let's say your share price suffers a fall, there's a diminution in the value of your shares, you would say that the person who suffers that diminution should sue, right? So imagine a company is harmed by the directors, right? And the share price falls. And before my share, the value of my shares in my pocket was £10,000. Now it's £500. Can I sue? Can I sue, yes or no? Because I've lost 9,500 from the bad behavior of the directors, right? So previously my share was 10,000, now it's 500. Can I sue for 9,500? Yes or no? Does anybody think I can sue? Why? Why can't I sue? Yeah?
Because the director's duty is to the company, not to the shareholder personally. So as a shareholder, you couldn't sue just for your loss. If any, it would have to be the company, the one that could sue for the whole loss suffered by the company.
Yeah, okay. So duty, so basically you're saying that the legal relationship is between the director and the company. So, but what if, let me change the scenario somewhat. So imagine the company had a box of money and the director obviously had the key. So maybe the shareholder actually for some reason had the key, right? There's nothing wrong with the shareholder having the key of the box of money. And then the director then comes to the shareholder and tells the shareholder a lie to cause the shareholder to part with the key. And then the shareholder gives him the key. And the director then opens the box and loots it and flees with his plunder. Now, can the shareholder, who now has seen a diminution in the value of his shares, because maybe there's 10,000 in the box before, so there was only one share, so 10,000 in the box before, the value of his shares was 10,000. Now that the box is empty, it's gone to zero. So what I've just done in this example is construct that legal relationship. There's a duty owed to me, right, not to cause me to part with the key wrongfully, right? Because here there's been a tort of deceit, right? There's been a deceit practiced on me. So I've checked your box. You said to me that the duty would only be owed this way, but in this example, can I sue? You understand the point? Yeah. What do you think?
I think that case would be different, but I'm still not sure if it would be because it no longer is.
Yeah. Yeah, please.
Both cases would say that the loss of the shareholder is only a reflection of the loss of the company.
Precisely. And I think that would be a stronger way of dealing with it. Of course, you're right in the way you put it, right? And that explains the cases. The only reason I gave you the Peskin and Anderson case, because when you read Peskin and Anderson, it discusses the previous cases, on this. And those previous cases defined it more as the duty is owed, right? It always says, well, the shareholder cannot sue because the duty is owed by the director to the company, and therefore there's only that legal relationship. But I think that's misleading. It's correct, but it's a bit misleading because that cannot be determinative. And what I've just done is construct an alternative, or rather a coexisting legal relationship to create the spectre of a double recovery problem. And you then said, well, we have to avoid the double recovery problem by recognizing that the loss of the shareholder is a reflection of the loss of the company, right? We can't allow the shareholder sue for the tort of deceit and claim 10,000 damages, right? And then at the same time permits the company to sue for the wrong of the director, and also permit the company to get damages, because then there'll be double recovery, right? There'll be double recovery. So the way you solve the double recovery problem is to recognize that the loss of the shareholder is a mirror of the loss of the company, and therefore you simply insist on the company suing. Right? And that would be a better way of dealing with it. So to whom is a fiduciary? So we said the company. Now, is it possible for the director to have a fiduciary relationship with a shareholder? The answer is yes. In a case, before this, Percival and Wright, the argument was that, well, because we are in a fiduciary relationship with the company, we could never be fiduciaries of the shareholder. And the answer is clearly no. That's wrong. You can be a fiduciary of the shareholder if you put yourself in a power position, isn't it? Remember our discussion about the fiduciary last time. So if you say to a shareholder, trust me in this deal, all right, then you're creating a fiduciary relationship, right? So, and that's what you see in the Peskin case, because you see the court basically recognizing this. Take a case of two brothers, right? You have two brothers. One, basically, they're controlling a BMW franchise, and one relies on the other brother to manage things for him, right? And that brother then cheats him, right? And misleads him and all that. And then he now sues the brother and says, you're my fiduciary. And the brother says, no, you don't know I owe my fiduciary duties to the company. But you've put yourself in a position of trust and power, right? So the other point is, who is the company? What is the company? Who is the company? What is the company? Now that may sound metaphysical, but it's important, because if we don't articulate who is the company, what is the company, then how do we give reviewable content to this duty? How do we review it? Right? How do we review directors when they claim to exercise powers in the interest of the company? So we've got to be clear about who the company is. So who is the company? What is the company? Yeah.
So it's a good person who has assets and business contracts, basically independent of the shareholders, because they can change, they can come and go. It's a legal entity.
Yeah. So how do we give reviewable content to the corporate interest? Because isn't that the question? So for purposes of reviewing directors, the exercise of their duties, if you're going to review, if you go to court and you say the director breached his duty to the company, how do you persuade a court that that is the case without articulating what would be in the interest of the company? Now, what you said seems to write the shareholders out of the picture. All right? You've articulated the concept of a company as a separate commercial entity detached from the shareholders. Right? I know you want to resile.
Well, I think.
But you don't need to.
Yes.
So tell me, what are your views?
I think it is somehow independent, because the shareholders can come and go, as I said, because the company still exists. So you cannot just see. But so far the shareholders are there. There's like this clear relationship between the company and the shareholders.
Yeah.
But
Okay.
it's not a relationship which will probably last forever.
Because, obviously, because shareholders don't live forever. The other time we started this course when I blasphemously said, what's the common thing between companies and God, and and I concluded it was all in the mind, isn't it?
Can we admit that the company is its charter and bylaws?
Yes.
So outlining
So,
the purpose
okay.
of the
Yes.
company.
Yes. Yes. That's good. So So we amalgamate the two things that have been said. She says the company is something we imagine, right? We can't touch it, we can't feel it. It's in our head. That's what you say. Well, no way. Okay. And I like putting words in people's mouths if it's consistent with what you're saying. And then you then say that to know its purpose, to be able to review anything to do with it, we need to look at the law that sets it up, the charter, the constitution. And when we look at that law, what does the law say? One, it says, we form a company for a lawful purpose. That's why Linda Sinclair, who was doing French lessons, had problems convincing the Attorney General and the courts that it was lawful. Not normal French lessons, by the way, just in case you joined the class late. But then we also know that Section 172 of the Companies Act tells us about the corporate objective. And so 172 tells us, that's the key to reviewing it, isn't it, to giving it content. It says that the directors should promote the success of the company. They should promote the success of the company. They should consider a range of interests. So she was struggling with shareholders. On the one hand, she pushed them out, but later she brought them in, and we see this tension in 172. So the prevarication that you experience with shareholders is also a prevarication that the law has had to grapple with. Right? So when you look at 172, it's talking about the company as a separate entity, promoting the success of the company as a separate entity, but it's also saying that we're doing this for the benefit, right, of the shareholders, right? So we've got to bring the shareholders into the picture, and then it's saying that in doing this, you have to have regard to a wider interest, right? The community, employees, and all that. So, I mean, what do you think about that kind of formulation? Do you think that's, are you happy with it? Do you think, yeah. So, and so in other words, you don't think it's a forge or anything, but, right? So basically, we take the company as a separate entity, right? And bear in mind that, the shareholders are fundamental, but they're not everything. And therefore, we need to consider a wider range of interest, which is what your whole charter and stuff leads us to. Okay, so please look at that aspect, and which is what we then try to balance here when I say how and what interests are to be balanced. How and what interests are to be balanced. So how do we balance these interests? Right? Because I think we've arrived at the situation that we need to consider a range of interests, and I just want to see how in practice this would work. So how do you proceed to make this work in practice in light of Section 172? So let's take a company which is loss-making. It has employees. So the company is a doomed loss-maker, right? It's a doomed loss-maker. There's no point. There's no recovery in sight, right? So if we look at the spreadsheet, we can tell that if this company continues for the next 3 years, it will go insolvent by year 4, right? So what do we do? If the directors choose to run the company knowing that it's a doomed loss maker, would the directors be breaching their duty? Because remember, we have to give it reviewable content, and you said the way to do it is to look at the purpose and prescribed by law. to look at those relevant constituencies. And I'm just wondering, how would you deal with this?
You just tie their remunerations to their performance.
There's no performance. The company is a doomed loss maker.
About, I mean, the directors.
Yeah, it's a doomed loss maker. It's losing money every year. As daylight follows darkness, the company will go into insolvent liquidation by year 4. What do? Do you wind up the company today and give the money back to the shareholders? Or do you say, well, you know, we need to consider the long term? Who knows the future? Who knows the future? The fact that I say the company is a doomed loss maker, I'm simply using the benefit of hindsight, right? So in the present, we don't know what the future holds. The law basically tells us to have regard to the long term, which, by the way, is unknowable. The law tells us to have regard to the interest of employees, and these employees, you know, deserve their wages. You know, the law tells us to have regard to the interest of the community. I mean, I could go on. I'm just listing the factors in 172. Gambling. I won't go that far. But, yeah.
I think the first place comes to the company, and as such the shareholders, and their common interest is not to lose money. So, and of course there's a duty to the employees, but I would say the duty to the company itself is more important.
So you're promoting the success of the company for the benefit of the members.
Yes.
And that's the core primary duty, isn't it?
Yes.
Promoting the success of the company for the benefit. It doesn't say for the benefit of the polar bears or whatever, but for the benefit of the members. So that's your starting point. And that's the irreducible minimum. And every other thing becomes subsidiary, including the workers. Yes?
Yes.
Yeah. Okay? Yeah. Yeah.
Well, so I think that the law requires directors to stop the operation and try to maximize what the creditors can collect.
But when creditors' interest only comes in when the company is in. Yes. So if the company is not yet doubtfully solvent, right? If the company has not sort of entered that the event horizon, huh? You get to the event horizon, the point of no return. I'm sure you know this in black holes and all that, right? So if you've not reached that point, then the duty to consider creditors' interest doesn't come up.
Basically, as as you said, nobody knows the future, and every director think of going concern and just try to maximize the profit and get out of the trouble and going on the operation. That's more realistic.
Yeah. So I mean, okay. I just so that we don't lose focus, I think the analysis you started with is the starting point, promoting the success of the company for the benefit, right, of the members, and then having regard, right? And now the point you're bringing in, i.e. the creditors, my point is that they don't come up at this point. Indeed, and if you look at Section 172, it doesn't mention creditors. But it does indirectly. I'll tell you how it does. If you look at subsection 3 of Section 172, it then says that, you know, directors should, it ties directors' duties to the law, right, the common law. And the wording of 172 subsection 3 essentially means that, bear in mind the common law position that when a company is insolvent, the creditor's interests intrude. All right? So insolvency would be one, or where the company is doubtfully solvent. Now, I've given 4 years. It's not doubtfully solvent. We know it's solvent, but we know that later on, the company will go into insolvency. So I'm kind of thinking that in that kind of situation, the shareholders would say, wind up the company today, let's get our money. Why are you distributing our money to the employees? Wind up the company today. And I think your point is that you say, correct me if I'm wrong, the shareholders should succeed. And you say that it's difficult to look into the future.
Yeah, maybe if I'm a director, I will try to do best to.
Yeah. So there's going to be a tension between your duty to promote the long term. So it would then really depend on what a judge thinks about your ability to, in a sense, guess the future. So if it's, a normal trading company, it's going to be a bit more difficult, right? But if you're doing something that is closed and it's pretty clear that nothing's going to change, then I think the courts would say you've got to wind up the company, right? We can't fudge it. And so in cases like Rewelfab Engineers and Resol Harrison, you get this conflict, right, between shareholders and employees. But in all those cases, I'll come to you in a minute, but in all those cases, the directors refused to wind up the company and carried on. And the courts basically said, we are not going to hold them liable. And there are two reasons why the courts will not hold them liable. The duty in Section 172 is a subjective bona fides duty, isn't it? So it's looking at what the directors themselves think, right? So the courts are going to be very careful about reviewing directorial decision making, right? So that's the starting point. So if the directors say, this is what we believe, then most times the court will accept it, right? Because of subjective good faith. That's the first reason. The second one is that in those cases, these were trading companies, right? And as I said, in a trading company, the court is going to be reluctant to guess the future, to say that what happened was always bound to happen, right? And that's why I gave a carve out, and I said if the facts are different, then yes.
So I was going to ask what Aldo said about their duty first being to the shareholders. Could, in an instance where it is rather black and white whether or not they're going to go to insolvency, if they then decide that they couldn't have predicted the future, could it be argued that they've breached their duty to exercise reasonable care, skill, and diligence? Because one would have diligently said, okay, it looks like we're not going to come out of this area, so we should just wind up the company.
Yeah, a good question. In other words, the question is that the subjective bona fides principle inherent in Section 172, which is really expansive, right? Could we outflank it by using the duty of care and good faith, care and skill? So could we outflank it? Theoretically, yes, right? But if you read Regent Crest on your list. In Regent Crest, ask yourself this question: why didn't they outflank it? And the facts were this: two brothers, blind brothers, right? With a lot of drive, they built up a company. I think they're called the Richardson brothers. Built up a company, and then later on, and they supported the company financially, even when the company had financial problems. And then later on, a few days before insolvency, so let's say about 10 days, 12 days before insolvency, after supporting the company, throwing in a lot of money into the company, decided to ratify certain wrongdoings by a director. And the way they did it was to release what they call a clawback claim. So they had a claim, the company had a claim against the directors to claw back money from them in regards to some property dealings. So the Richardson brothers decided to waive the clawback claims, and the consideration for waiving it was to say, well, we need these guys to work for the company, right, for free. But about 12 days later, the company goes into insolvent liquidation. Now, it seems clear to me that the Richardson brothers knew that the company was going to collapse, and they wanted to take care of their body, right? They wanted to take care of their body by waiving it, by releasing this clawback claim. Now, so the company goes into insolvency, and then the liquidator brings an action. So you would expect the liquidator to go for the breach of the duty of care, right? Knowing that subjective bona fides is really strong. And he didn't. And of course the case was lost on subjective bona fides. So it's on your seminar sheet, and I just want to flag this up. So notice the timeline. 1990, company is in financial difficulties. So you see them injecting money up to August 1990. Then September, the defendants, the brothers, voted on the board in favor of a resolution to waive the clawback claim in consideration of the vendors giving their services free of charge to the company. The idea was for the guys to work for 3 years, blah, blah, blah. And then, so September, yeah, my calculation is right, thereabouts, September 17th, right? A petition was presented to wind up the company. Now, the defendants, the claimant company, rather, by its liquidator, brought an action against the defendants, claiming damages for breach of fiduciary duty. As a director, in voting in favor of the waiver. Now, the clawback claim was worth 1.5. So the action was for damages for breach of fiduciary duty, and what was the defense? Essentially, the defense is that, well, it's according to our subjective good faith. They basically said 172 is not engaged, right? Because we subjectively thought this was fine. And her question is, correct me if I'm wrong, I'm putting words in your mouth, is why didn't we use the duty of care? And I think there could be no, I mean, I wonder, why didn't they do that? And I can't see the reason. I mean, the only problem you will have with the duty of care is that of causation, which you will see in the other case, Simmons box, right? So in Simmons, so it's not enough to show that there has been a breach of the duty of care. You've got to show that that breach caused the loss. And this is something we tend to test in exams when, we talk about the financial crisis and we see a board making some crazy decisions. So there's clear negligence, but we've done in such a way that you can't trace the negligence to the loss. And then everybody says, not everybody, but people say, oh, breach of duty of care, therefore we can sue. No, you need causation. You need causation. And the case on causation is the Simmons box case, where, again, on your seminar sheet, I'll spare you this. I'll just on your seminar sheet, where I'll just give you the facts so that I don't get, because we don't have time. But basically, to say that here. Right, so I'm talking about Simmons box, the duty of care. So the guy basically, so this guy, he's a director of the company. He goes to Japan to learn a foreign language, well, to teach English. And then he leaves his father to manage the business. The father is not a director. Father takes the entire stock of the company, diamonds, in a bag, and goes to Europe. And conveniently, he's asleep on a ferry. And he wakes up, the bag has disappeared, no insurance. So therefore the company goes into liquidation. So the son is sued, right, for negligence, breach of duty of care. And it's clear that he was negligent, but it wasn't clear that that negligence caused a loss. Because how do you show that his negligence caused a loss? For you to show this, it has to be clear to him that his father is the kind of guy who will do this and will never insure it. Do you see? So if you're going to use the duty of care, then that's the only problem you'll have, which I don't think they had in Regent Crest, right? So I'm sure when you have your tutorials, Nigel will dig in more in the cases. So I look forward to seeing you at our next class, and we'll be dealing with that particular seminar which I just uploaded.
We've got a really great lineup of speakers, so yeah.
And so, like, almost the whole day is from 9:30.
Yeah, it's a whole day, so whatever you can make, but...
No, but I don't have classes. So
Oh, perfect, okay. So in the morning, we have the annual lecture, and then we have the keynote panel after that, so the morning's 8:30 good. But then there's one reception at the end, so that's also what we're staying for, and all the rest of the panel.
Yes? Väldigt rolig morgon för oss bägge. Det var också det jag sa, det var väldigt. Då var du hemma.
Yeah.